I now call upon Dr. Subramanian Swamy to begin the debate. Thank you.
Thank you very much. It was not pointed out that I'm the only non-lawyer here, which means I can, and a politician to boot, which means I can say anything I want, whether you like it or not. Justice must not only be done, but it also must be seen to be done, well known. And what the main issue here is, of course, it is stated in the brochure that this House believes that India's judicial appointments need legislative interference. Now, the word interference is a difficult one, but I certainly think that legislative in all countries of the world that I have studied, not many, but I have studied many, and they do not have a situation like ours. There is an interaction between the bureaucracy, the parliament, and the law. And in India, it's not so. The lawyers, the Supreme Court, for example, is totally on its own. It's the parliament and the bureaucracy has no real no strength in speaking to them or about them. The Constitution recognizes and embodies a broader version of checks and balances. That is there, of course, it's well known. A limited legislative involvement, therefore, is not interference, but legitimate way to regulate the procedure and reinforce public trust and accountability. Under Section 124(3)(c), a necessary qualification for becoming a judge in the Supreme Court is that the person must be an eminent jurist in the opinion of the President. The emphasis, therefore, has always been on involvement of the legislature and executive in the judicial world. Parliament already plays a crucial role in maintaining judicial accountability. Under Article 124(2) of the Constitution, judges can be removed through impeachment. If the legislature cannot remove the judges, it is only logical that it should be a measured role in appointing them as well. Comparative constitutional practice supports the balance. No other major democratic country in the world follows the system under judges appointing judges, which is India. India is appointing judges. That is not there in the world. And without any interference from elected officials who represent the will of the people. In other countries, for instance, the United States, the Senate will summon them, examine them, and so on and so forth. None of that happens here at all. Judicial independence is vital, but independence does not mean isolation. A calibrated legislative role brings transparency, accountability, and democratic confidence to judicial appointments. In other words, I think what we are saying is that at present, the Indian judiciary, especially at the top level, which is the most important, is totally a law unto itself. And there is hardly any interaction that takes place between either the bureaucracy or the parliament. All the 6 times I was in parliament, I never saw any judge being summoned or asked to explain or any such thing. It's always a feeling of awe about the judiciary. So what my argument is that we should follow somewhat, if it's not offensive to some people, the American system of having judges who are selected to go through the committee of the what is the equivalent, what we call as parliament, and they call it this, the state. So hence, that recognition, if that takes place, in my opinion, much of the problems today of favoritism and things like that, which have been coming regularly nowadays, that will completely go away if a person is chosen as a lawyer or as a ruler in the place. They have to be summoned before the parliament, and they should be questioned and they should be answered. There's no question of anybody being to be hurt or anything. Otherwise, it's just basically a way the country will be able to see it. This House, therefore, must believe that India's judicial appointments need legislative interference. And the interference that we need has already been mentioned by me in 2 or 3 ways. There are many other ways. Altogether, I think this is the only way by which we can improve our legal system. Otherwise, the legal system will become a law unto its own self in the way that common people will find it very difficult. Thank you very much.
Now we would like to call upon Mr. Sai Deepak to talk against our motion. Thank you.
I'm grateful to the organizers for having made the impossible possible through the composition of the panels. People who never thought that they would actually share space with you finally managed to share space with, and also we have this occasion to speak on the same subject, hopefully in the same voice. As I understand, the topic says that the House believes that judicial appointments must have legislative interference. Now, the good part about the framing of the proposition is that it does not speak for or against the institution of the collegium itself, which means, as I understand it, the way I have carved out the proposition for myself is that I am not here to defend the institution of collegium. Rather, I am here to define what is legislative interference and push back against it. That's how I see it. Because the question was not whether there's a choice between a collegium and legislative process. The question is whether there should be legislative interference in the appointment in judicial appointments. That's how I see the question. So going by that, let me start with creating some kind of a sliding scale here for people to understand what are the different options available. First is the provision itself, which speaks of the appointment by the President in consultation with the Chief Justice of India. Now, that has been the subject of at least 3 landmark judgments and subsequently 2016. You have one system which effectively creates a bubble of sorts, which is the collegium system, where judges decide for themselves on the basis of a consultative process which is internal in nature to understand how the appointments will come about, of course with some kind of inputs, which may be sensitive inputs with respect to security considerations that may be received from the executive. Then there is the other end of the spectrum, where the appointments are effected either by the executive or the legislature. Here the question was not about executive interference, the question was about legislative interference. And therefore, we are not on the question of whether political parties or the government of the day shall have the right to appoint or make judicial appointments. It's a legislative interference. Now that we have struck a distinction between the executive and legislature, the next question would be, what is interference here? My sense is interference would be not the right to vote, but the right to veto. If the legislature has the final word on judicial appointments, then that becomes interference in my submission, which is to say, what would that bright red line be, which if crossed would translate or transgress into interference? So you have consultation, you have concurrence. Where do you think interference falls within which basket? I would say concurrence, which is if you can't take a decision with respect to a judicial appointment without the concurrence of the legislature, that would, in my view, become interference. Now, this is a matter of semantics. Let's go a step behind, which is the meta question, which is, what is it that you're trying to protect? Are judicial appointments the only sui generic form of appointments which are envisaged within the Constitution? Are there no comparable positions within the Constitution itself? For instance, the Election Commission, the Chief Election Commissioner. The Chief Election Commissioner, as T.N. Seshan rightly pointed out, the legendary Al Seshan pointed out once, and he himself called himself that, and therefore no offense is meant here, which is that he was an employee of India, but not the government of India. And therefore, he struck a very clear distinction between the state and the entity, the body politic. I would submit that whether it is the Chief Election Commissioner or judicial appointments, in particular to the higher judiciary, would therefore fall in largely similar baskets, if not identical. Therefore, if you wish to understand what should be the position with respect to the appointment of judges to the higher judiciary, you cannot do so without understanding what is the Supreme Court's latest take with respect to the appointment of the Election Commissioner, wherein some kind of a broader process has been conceived of. I would be in support of a position which preserves judicial independence with respect to the final say, subject to inputs being taken from both sides of the aisle, the Treasury as well as the opposition. That's how I would go about it. One of the reasons that I would believe that this is the best way to preserve judicial independence is if you've ever been a litigant or a litigator, the behemoth in the room, if there happens to be an opposite party, and if it happens to be the state, is always the state. The state, if you look at the statistics, the state is actually the most litigious entity in the country, going by any number of studies, including the National Litigation Policy. And when the bargaining power between two parties is practically non-existent, I would expect that you offset that difference in bargaining power by ensuring maximum possible neutrality of the person who operates or who sits in that particular position. There are two ways that you can look at this particular issue, and I hope that the audience considers what I'm trying to say. You can either look at this particular issue through your respective political lenses, in terms of who's in power and who the bench is against, or you can put yourself in the shoes of a litigant or a litigator and ask yourself, are you not better off having a neutral person regardless of who is in power, as opposed to loading the dice depending on the dispensation of the day, or the ideology of the day, or the favorable winds of the day? That's the larger question. And if you look at Constituent Assembly debates, particularly debates which dealt with the draft Article 103, which was the predecessor article to 124, discussions revolved around preserving the independence of the judiciary to the maximum possible extent. And I'm going to say something which could sound classist, elitist, so on and so forth, but nevertheless, I think at least somewhere we must have the ability to speak the truth, and the spade must be called a spade. You are not in a position to compare yourself with an America, New Zealand, Australia, or any of these countries, not yet. I'm sorry to say that. I don't think you're in a position to actually say that where democracy has been fully democratized, where the power of adult suffrage, universal suffrage, or franchise is capable of being bought for a biryani packet or a bottle of alcohol, and which is still largely the truth regardless of which part of the country you go to. This is not limited to any particular state or region. I believe that this is a fairly pan-India phenomenon. There, I think, is unity in diversity. I believe that there must be one check in that place, and that hope has been the judiciary traditionally. And if you look at the track record of the judiciary in this country, every time the executive has failed us, people have reposed faith in the institution of judiciary. Kindly strike a distinction between two different issues. One is judicial accountability and judicial appointment. We are on the question of judicial appointment. It is possible to ensure accountability without interfering with the process of appointment, which means perhaps you could have greater standards of disclosure with respect to assets, greater standards with respect to conflict of interest, You could have greater standards with respect to how a person can be removed from the office. But don't conflate that issue with the question of judicial appointment. If you do so, in my humble submission, you will walk into a trap and you'll forget what the issue is about. Kindly, constantly focus on the issue. The three central words would be judicial, appointment, and legislative interference, 4 words. So don't conflate the legislature with the executive. Don't conflate appointments with accountability. Thank you.
There we go. Okay, thank you so much, Mr. Deepak. I will not be allowing questions from the audience. You'll get to do that later.
We would like to call Mr. Justice Sidharth Mridul to the podium.
Good evening. So evidently I've come in as the pinch hitter because I was supposed to follow my friend Gopal Shankar. Never mind. So let me begin on a more sedate note after the excitement generated by my friend Sai Deepak. And I completely disagree with him when he says that judicial appointment and judicial accountability can be put into 2 separate buckets. They cannot. We are talking about the same animal. I'm sorry to use that expression, but we are talking about the same animal. Now, the Constitution of India is the supreme law. It is the fountainhead. So let me start there. That's a very good place to begin. Article 124 of the Constitution of India, and I'd like to read it out for all of those who are here, because that will give you the perspective in which I support the proposition. The article reads thus: every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation, keep that word in mind, consultation with such of the judges of the Supreme Court and of the high courts in the states as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 now. And in the case of a Chief Justice, the other judges have to be consulted. Now the expression is consulted. I think if you read the plain dictionary meaning of the expression consulted, and I will come directly to that, consultation. What is consultation and what is concurrence? Consultation means deliberation of persons on some subject. A conference between the counsel engaged in a case, for example, to discuss its questions or arrange the method of conducting it. In French law, the opinion of counsel appoint a point of law submitted to them. So this is merely an opinion, a consultation. It is vastly different from concurrence, which is what Sai Deepak was emphasizing. Concurrence has been introduced by judicial interpretation. If you go back to the first judge's case, in fact, I'll go back even further. Let's go back to the Constituent Assembly debates. And I differ once again with Sai Deepak, because Dr. Bhimrao Ambedkar, the architect of the Constitution, very clearly said this when it was suggested that the Chief Justice of India must appoint judges. This is what he said. With regard to the question of concurrence of the Chief Justice, it seems to be that those who advocate that proposition seem to rely implicitly both on the impartiality of the Chief Justice and the soundness of his judgment. I personally feel no doubt that the Chief Justice is a very eminent person. But after all, the Chief Justice is a man with all the failings, all the sentiments and all the prejudices which we as common people have. And I think to allow the Chief Justice practically a veto on the appointment of judges is really to transfer the authority to the Chief Justice, which we are not prepared to vest. I think it can't be clearer than that the Constituent Assembly, after applying itself to the question to this very issue, enacted Article 124 in the manner which it did, which warranted the President of India, on the aid and advice of the Council of Ministers, to consult the Chief Justice of India when it came to the appointment of judges. There was no question of concurrence. In fact, that is precisely what the Supreme Court Constitution Bench decided in the first judge's transfer case.
In our case, when Dr. Ambedkar had made this speech, we didn't have the basic structure doctrine in place. The basic structure doctrine never came about even in the Constitution. It was a judicial interpretation. And first judge's case onwards, all stemmed from there. So is it wrong for the judiciary? Is it overstepping its mandate by interpreting what the basic structure is?
It's a wonderful question, and I'll come to it directly. Is the system of checks and balances a part of the basic structure of the Constitution? Isn't it? So when the plain words of the Constitution ask for concurrence, for consultation, can we read it as concurrence? First of all. Second of all, that the system of checks and balances is two-way traffic. On the one hand, you have judicial review of all legislative enactments. That is a check on the power of the legislature. Similarly, you have a check by the legislature on the part of the Chief Justice of India to appoint judges. They cannot do it without their inputs. It's a blend of both executive, legislative, and judicial, which is what the National Judicial Appointments Commission was all about. Now, let me talk about the composition of that commission. All three judges of the Supreme Court, including the Chief Justice of India, and Sai Deepak alluded to it, so therefore I must refer to the NJAC, because he referred to the composition. Then it included the Prime Minister of India, a very high office. It included the leader of the opposition and the law minister. So it took into consideration the views of not just the judiciary, but also the executive and the opposition, who were also speaking for the legislature. So therefore I believe that to give an interpretation, and therefore I will deal with why the Supreme Court interpreted Article 124 in the manner in which they did. How did they convert consultation into concurrence? Right? Now let's go to that argument directly, because I will not, I could go on for a while, but I have time constraints. I'll come straight to it. The finding of the Honorable Supreme Court is that the appointing authority, which is the President of India, is not in a position to appoint judges because he has no familiarity with them. In my respectful view, it is familiarity that we must do without. It is only when you are familiar with the individuals who you seek to appoint that you have difficulty with Bhai Bhatijawad, as it is called. Right? And I must also distinguish between judicial independence, right, and judicial supremacy. The distinction is simple. The distinction is that you are trying to make sure that the judiciary is kept away, protected from the pressure that may be exercised by either the executive or the legislature. What about insulating other judges from judges? What about, which will bring me to the next question, of course, the manner in which the collegium system has functioned? And I think I should come directly to the personal experiences of judges who are still on the bench about what they have said about the collegium. Justice Rumapal famously described the collegium as one of the best kept secrets in the country. Right? She said decisions on appointments and transfer were made behind closed doors with no published criteria or reasons. She further said this secrecy undermined public confidence in the judiciary. And she concluded by saying that while independence was preserved, transparency was sacrificed. She said the collegium does not lay down any clear, objective standards for selection. She noted that merit was often undefined and appointments could be influenced by personal preferences or informal considerations. Without codified norms, the process risked arbitrariness. She observed that the collegium functioned as a small, exclusive group of judges making decisions without wider consultation. I think I'll end with that. Yeah. Sure, go ahead.
Mrs. Mridul, the question from Mr.
I'll take
Deepak.
the question.
Okay, yes.
Actually, this is the second question I'm fielding.
So are you comfortable with it?
I'm
You
fine. I
You're
can
not allowed to
answer as
decline
many
one
as you
question.
want.
You can decline the second one if you'd like.
It's the first time I'm in the dock, so I don't mind.
So the question is,
Right.
since you focused on being close to the dictionary meaning as much as possible,
Right.
haven't there been instances where statutes using may have become shall and shall have become may?
Absolutely.
In which case, why do you insist that consultation must just be consultation and not just
Because
concurrence in light of the context?
I get the point. The reasons behind treating consultation as concurrence was in view of their understanding that the judiciary had to be protected from legislative and executive interference. Right? Now let me answer that practically. Since the commencement of the Constitution in 1950 till 1993, judicial appointments were made by the executive. Did we find anything wrong with it? Did we ever complain that there was interference by the executive in the appointment of judges, or that there was favoritism, or that there was nepotism? I hope that answers your question. I will not venture into any personal experiences, but I hope that answers your question. Thank you.
We would just like to reiterate that the audience may ask questions if the opposition doesn't have any. Thank you.
Thank you so much for enlightening the debate, Mr. Mridul. It's delightful to have you here. Now we would like to call upon Mr. Akhil Sibal to tackle Mr. Sidharth Mridul's speech. Thank you so much.
Good evening, everyone. Thank you to the Delhi Union for inviting me, and thank you all for being here on a Sunday evening. Justice Mridul's reading of the Constitution on this issue is, of course, disagreed with by 9 judges of the Supreme Court, and according to me, with good reason, The first reason that you should vote against the motion is because it's entirely vague. You're asked to vote in favor of legislative interference without being told the nature of the proposed interference. Already we have 2 of those supporting the motion saying very different things about the interference. Mr. Swamy says perhaps the political model of the US. I think looking at what's happening in the US, we should take no lessons right now. And Justice Mridul talks of the NJAC, which ensures that any 2 out of the 6 can veto the decision, which means that the final word is taken away from the judges. And I want to explain what danger that presents. I assume that all speakers would agree, as also the members of this House, that the independence of the judiciary is worth preserving. To uphold the rule of law, it's necessary that a judge decides without fear or favor, without feeling beholden to anyone, or out of fear of facing personal consequences by deciding in accordance with law. A judge should not be motivated in her decision making by any particular political leaning or personal prejudice. A judge should not in any manner be personally interested in the outcome of a case. These are some of the facets of judicial independence. I hope members of this House would agree that if legislative interference undermines judicial independence, this motion must fail. One of the key features of judicial independence is to be independent from executive influence in legal decision making. In other words, the government should have no say in deciding the outcome of a particular legal case. Independence from the executive is especially essential because the government is the biggest litigant in our courts. As it is for a citizen to challenge governmental action, whether inside or outside the court, is not easy. Now imagine if the person deciding a case involving the government is partial to the government. The government would then be free to misuse its powers without fear of judicial scrutiny. So the question is, would voting in favor of legislative interference mean allowing the government to encroach upon judicial independence? I would argue a resounding yes. Let me explain. The legislature is comprised of members of a party or parties in majority that form the government of the day, the treasury benches, as it were. The members of the opposition are those who wish to form the government in subsequent elections. So whether it's the treasury or opposition members, they will always have an institutional interest, a bias in wanting to be able to influence judicial decision making, because when in government, regardless of the political party, it will help to dilute the constitutional check on government excesses through judicial review. In short, at an institutional level, the legislature always wants to expand its influence over the judiciary and to control it as much as possible, because a pliable judiciary is advantageous to the government of the day. Now, because of the principle of separation of powers, the executive cannot directly participate in legal decision-making and cannot be a judge in its own cause. So the next best route to interfere with judicial independence is to try and control the selection and appointment of judges. Now imagine if you're a litigant before the court and you have a case against the government, comes up before a judge who's been selected and appointed by that government. Would you not reasonably harbor a doubt about the independence of that judge from the government? It's imperative, therefore, that primacy of the judiciary in judicial appointments is retained. And it's not as if the current collegium system, the government has no participation. Government can send back a recommendation for reconsideration. What it does not have is control, which it should never have, because there's a direct conflict of interest. In short, primacy of the judiciary in judicial appointments is the cornerstone of judicial independence and must be maintained. This is not to say, and that's the attractive argument that will be made, that all is well with the collegium system. You can advocate, as I do, greater transparency and reform within the collegium system without supporting this motion. I'm a stakeholder in the system. I believe there are areas which require improvement, but the functioning of the collegium is one of those areas, but you don't throw the baby out with the bathwater. The judiciary, with all its flaws, still stands tall amongst institutions which have one after another capitulated to the pressures of the government of the day. The only institution the government still occasionally fears is the judiciary. And there are two avenues for holding government accountable: the rule of law, in which the judiciary has the final word, or the people who elect the government. But once in power and until the next election, who will hold the government to account? And who will hold the government to account when a popular majoritarian government tramples on the fundamental rights of citizens? In fact, even with the current collegium system, and some of those on the panel supporting the motion are part of courageous, outspoken few who have pointed to the unseen hand of the government interfering with appointments and transfers. There is disappointment with the judiciary not strictly enforcing its own collegium system, allowing the government to effectively defeat recommendations, even when reiterated by the collegium, or the government sitting endlessly on recommendations till the recommended person withdraws rather than face uncertainty and humiliation. Surely, if in the current system where the collegium operates, this is how the government is still interfering, is the solution to the problem to give greater interference to the government? I would say no. The problem lies with implementation. Judiciary must rise to instill greater confidence in the process by being opaque and not standing up to the government sufficiently, by making questionable appointments and overlooking obvious choices for elevation. The judiciary has allowed a narrative to form, to introduce formal interference. But it's a trick. By pointing to the shortcomings of the collegium system as it has operated, the government wants you to allow them a greater hold over the process. And I would say, as a final comment, do not be drawn in by the appeal of an argument that points to the drawbacks of the collegium system and then proposes a vague solution of legislative interference. To vote in favor of the motion would be to weaken judicial independence under the false hope that legislative interference offers a solution. I would ask you to vote against the motion. Thank you.
Thank you. Thank you so much, Mr. Sibal, for your speech. That was quite a fiery speech, and I'm hoping the audience has some POIs. You're recognized? Yeah. Could someone run with the mic? Yeah.
My question to you is that you have taken the view of intervention to be one which favors the government per se. That means the intervention would be that the government would intervene in order to favor itself. What about a possibility where the collegium is favoring itself, and the government, or the legislative in this case, is intervening to do away with that favoritism which the collegium is doing? That is also an intervention, so that cannot be discounted. How do you address that?
Yeah, that's... Hello. So, good question, thank you. The distinction I would draw is that when it comes to the government is a litigant. Judges are not litigants. In fact, they cannot be interested in the case which they are judging in any manner at all. So that's what independence is. So how can a litigant have a say in who is going to be the judge? That's a direct conflict of interest. So it's not the same as far as you saying that, you know, there's a group of judges who may have some quid pro quo amongst themselves. It may be a small club. As I said, that is a legitimate question. It's a question of reform. It's a question of transparency. It's a question of instilling confidence in the appointments they make. And that is a legitimate ask. But the solution is not throw that system out and give the government greater control. That's why I say don't vote for the motion.
We're good. Now we're going to be moving on to the next speaker. Now I would like to call upon Mr. Gopal Shankar Narayan, proposition speaker. Thank you.
My gratitude before I start to the Delhi Union for having organized this and this tricky little substitution that I have to do for Dushyant Dave, which I discovered last evening. So pardon me if I'm not more eloquent, if at all that were possible. I just want us to just understand what the topic is again. This House believes that India's judicial appointments need legislative interference. So what the House is called upon to do is to determine whether at all there is such necessity. That's all. It's not about collegium systems, it's not about judicial appointments per se. It's about the measure that will be taken to address the situation. If the House believes that we are in an absolutely perfect scenario when it comes to appointing judges, the House very understandably can vote saying there is no such necessity. If, however, the House feels that there are shortcomings and misgivings with the existing system we have to appoint High Court and Supreme Court judges, even the slightest misgiving, then I believe your conscience should not permit you to come to any other conclusion except to say that we need to interfere with this system. The question then is, how do we interfere? One is to have riots and overthrow all governance structures. The other, possibly a better option, we would believe in this democracy, is to have a legislative interference. And in this, I read it broad enough to mean an amendment to the Constitution or whatever else the legislature may do. The system we are in currently, and I need to give all of you a bit of a history on this, which is that from 1950, Article 124 of the Constitution provided, as Justice Mridul read out to you, a system which called upon the appointment by the President of judges after consulting with the Chief Justice or other judges of the Supreme Court. We had that experience till 1993, when 9 judges of the Supreme Court sat together and decided this system, which has given us multiple supersessions, which has given us a supine judgment during the emergency where the Supreme Court crawled, this system, which has given us several imperfections, including senior-most judges being superseded and a couple of impeachments being initiated, calls for correction. And they thought in their wisdom that a collegium system should replace this. The word consultation was interpreted, as Akhil rightly said, as concurrence, compulsorily bringing the judiciary in and giving the judiciary a kind of final mandate. Now, like Oscar Wilde said in a completely different context about marriage. He said, the first marriage is the triumph of imagination over intelligence. The second marriage is the triumph of hope over experience. The reason I mention this is, in 1993, I can understand the judges were showing imagination and saying, we don't have another system, let's try this one out. Where, coincidentally, the judges who authored the judgment were themselves the first, second, and third members of the collegium. So they themselves gave themselves the power to finally decide who their judges are going to be, right? But we have had, since then, more than 150 judges who have been appointed under the collegium system. In these 23 years, we have had a series of examples which have shown us the complete lack of accountability and transparency of this system. And we know, and Justice Mridul probably knows this better than anybody else here, about the trade-offs that happen within the collegium. Your guy, my guy. I know this person, you know that person, that kind of trade-off, right? Now, because of the proximity that judges have to the community of lawyers from which these selections take place, more often than not, you will find nephews and juniors and other people that one is proximate to getting appointed. So this is the kind of imperfect system that we have had for so many years. My question to this House is that now after 23 years, it's Oscar Wilde's second marriage. You know what the system is. You know that your imagination has not served you well. You know that this system is far from perfect. We have a scenario today where out of 34 judges of the Supreme Court, we are in, and I've said this before, and I'm using the expression again, disgraceful position where we have only one woman in the Supreme Court of India. This is not acceptable at all. We have casteist considerations, we have religious considerations. Of course, Mr. Sibal is right when he says these can't be grounds for us to say that the executive should step in. But who's saying that? We are not saying executive step in. When the NJSC came in 2014, which is the amendment to the Constitution, bring on an alternate system, it said you would have the Chief Justice of India and the two senior-most judges. That's 3 out of 6 would be judges. Of the remaining 3, you would have one which is a member of the executive, the law minister, and 2 others who would be appointed, who would be citizens, who would be appointed from a committee of the Prime Minister, the leader of the opposition, and the Chief Justice of India. So the Prime Minister doesn't have a veto or control over that. So why did you strike down this suggestion? This suggestion was not putting control in the hands of the executive. So however powerful your executive is, the control is elsewhere. It's really with the judiciary still. What's your problem with that? What's the problem with the UK system where you have 22 members, of which only 6 are judges, and the rest of them are merely nominees, laypersons as they refer to it, members from the government and from civil society? Why don't we have a system like that? Why are we, as far as those who are opposing this motion are concerned, coming to a conclusion that we are drawing the line in the sand right now and we will brook absolutely no improvement? That does violence to India's democracy. I don't think the t-shirt that I wore in college, which said, a good lawyer knows the law, a great lawyer knows the judge, should hold true anymore. Thank you.
So, thankfully, you had some very fiery speeches. Thank you for adding to that, sir. I will now open the floor up. If anyone from the panel, if anyone from the panel has a question, you may say so. Anyone? Okay, Mr. Gagar.
Gopal, one more factor in that NJAC was that the 2 people who were to be appointed by the executive, so as to say, the committee, those 2 people could in fact veto or stall the entire process, right? They had the right. If 2 people out of 6 decide not to let something go forth, they can block it. Do you think that is fair?
Do I think that's fair? No. But do you think when 5 judges sit together in a room and say that, look, let's not go for the really good candidate who's got a spine, who's independent, who's bringing the government to account. So let's keep him aside and let's get my nephew in and your junior in. Do you think that system is fair?
Okay, now we're leaving the floor open for questions. So if anyone has questions, there you go.
Thank you so much, sir, for this discussion. I think I had two primary questions, and they're both directly relevant to speech Mr. Shankar gave. First is with regards to the issue of the trade-off. So if you were to look at it as a creature of lesser evils, right, the issues of trade-off or representation, as you rightly mentioned, could they sort of be viewed as a lesser evil than compared to the chance of an executive or a legislature, given the intimate relationship the legislature and executive share in India's system of them sort of overpowering? And second question, so sorry for the combined questions, goes to the aspect of how do we bring in this legislative interference, right? Because even if sort of a new collegium or new system, a commission is built up by an amendment that does have the challenge of the basic structure, as well as the aspect that you mentioned, the UK. The UK has the supremacy of the parliament as a central system, while we follow the constitution to be a separate system, separate from the parliament. So in reconciling them, how could we imagine that to go with Oscar Wilde?
Look, I agree with this latter point of yours, and I agree with Sai as well. Completely agree with what Sai said at the outset, that we are not a mature democracy yet. So to believe that these kind of notions of trade-offs and vyapari that you do with judges will not happen, I'm not giving you a guarantee it will not happen. But I believe that when you see imperfections in a small cohort of 5 or 3 as the case is, which are the 2 collegium we have, wouldn't it be a better system if you have a larger and broad-based body? If you have, say, 20, 30, 40 people, whatever it is, the chances then of the trade-off becomes, in my view, possibly tougher to navigate. Even if you have to do something like that, becomes tougher to navigate. Plus, the requirement of accountability and transparency. Right now, we have a system where the judges are willing to hold everybody and every entity accountable to a standard which they will not hold for themselves. Right? Now, there are, of course, honorable exceptions, one sitting next to me. But the fact that you will then insist on those standards in every other entity and not yourself is a real hurdle. The only way we can get over it is perhaps by a measure which will bring in a more broad-based system. That's my view on this.
So I have one question, and this is based on a clarification that I sought from Gopal just a few minutes ago. Article 79 defines the parliament and includes the president as part of the definition. And if Article 124 says that someone who is part of the parliament shall appoint judges, there is already a legislative participation in the appointment of judges, going by the language of the provision. What more do we expect beyond that? Second, I just want to, let's say, undergird this question with one presumption. The president's role or appointment is anything but non-political. The president is ultimately elected by a college, an electoral college. And at the end of the day, the dispensation of the day has a clear role. So as much as we would like to impute neutrality to that office, it is also the part of it is also an outcome of a political process. So the appointee of an outcome of a political process who is a part of a parliament under Article 79 appoints judges. My question is, what more do you want over and above this by way of legislative participation or interference in appointment? And is it your case that the government or any government of the day is less casteist in its considerations or less casteist than the judiciary at any rate?
Rescue me here. So, on the first point regarding president, president is considered for the purpose of Article 79 as part of the parliament, but that's for perhaps a slightly different reason, because the president also acts as an authority who makes law by virtue of his ordinance making power under Article 123 of the Constitution when parliament is not in session. the president's role here, and when you ask what more do you want, what more I want is simply the fact that as things stand today, those two 9-judge decisions that we have had of 1993 and 1998, the second one came in fact on a reference by the president asking for advice of the Supreme Court, reiterate that we have a collegium system in place and that's what is going to be followed. Now, the interpretation that has been given to a constitutional provision means, and that's the system here, means that the words of the Supreme Court become part of the Constitution. That's the way the Constitution is today. So the Constitution that you hold in your hands has to be interpreted in light of judicial interpretation. Now, that being so, Parliament in its capacity as a legislature can make no changes today to the appointments of judges, which is why in 2014, Parliament had to first amend the Constitution, insert Articles 124A, B, C, because the Constitution itself had been changed by judicial interpretation. Consultation had been read as concurrence. So thereafter, the only way that can be repaired is either that an 11-judge bench overrules the Supreme Court's position, or the Constitution itself is amended. So it's not Parliament alone which will have to make the changes. It's Parliament exercising its constituent power, which in this case will require the consent of at least half the legislatures of the states under the proviso to Article 368, subclause 2. That will have to be followed through. So, which is why I think the way forward is perhaps that as a starting point. And second, what do I really look for? Because I don't believe that I have the imagination, I don't have the information, I don't have the knowledge of what possible systems we could explore. I believe that there are 543 parliamentarians who have been elected for this purpose, who will bring their experiences, who will bring their backgrounds, who will carry all of that into a debate, into trying to redefine, refine, expand, and create a better system. Still not perfect, but better. I think we should move in that direction.
Thank you so much, Mr. Shankar Narayan, for being so active in this debate.